Mr. Malero, are you there?
I'm here, Judge.
I have Mr. Madrid from the jail. Do you need a breakout session with him?
Yeah, just real quick, nothing bad or too long.
Okay, one moment. Ms. Dumont, is Mr. McCormick at your office with you?
Yes, Your Honor, he's right here. And we're ready.
Okay. This is file 24-21705-FH People versus Wesley Allen McCormick. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Katarina Dumont for Mr. McCormick.
Okay, and I'm sorry, so we have two cases here today. 23-21647-FH and 24-21705-FH. Both are set for pretrial. So Ms. Dumont, where do we stand with Mr. McCormick's case today?
Your Honor, we did get a pretrial offer and I did get a Cobb's agreement in which the court agreed to no more than 60 days jail up front. What we're requesting is another pretrial date in which we can maybe 30 days out, in which Mr. McCormick can continue the counseling he's in and the drug tests. He's currently drug testing 2 times a week plus colors. He's in counseling 4 times a week, 3 group, 1 individual, for a total of already 22 sessions. Our perspective is if we can show the court that he's ready for probation without any upfront jail, that is our goal. And I think if we get a 1-month adjournment, we can show the court that he's continuing on a path to sobriety and recovery.
Okay, Ms. McClure, anything to address from the people's standpoint?
I would leave it in the court's discretion.
At this point, I will agree with that adjournment. So we'd be looking at about 30 days would be April 17th. Let's go with April 17th at 8:15 a.m. if that works for everybody.
Yes.
That works.
All right, Ms. Dumont, would you prepare that stipulation in order, please?
Yes, Your Honor.
Okay, I think we're all set with this one then. Thank you. You can go ahead and log out. Mr. Sala, I just had Mr. Highland pop into the Zoom waiting room. I'm bringing him over now. Are you going to need a breakout session with him?
Yes, please. I don't need a breakout. No, we're okay with that. I'm sorry.
Okay, you're just ready to go then?
Yes, sir.
Okay. All right, Mr. Highland, are you able to hear me?
Yes, Your Honor.
Okay, we are on the record in file 23-21536-FH, People versus Matthew Lee Highland. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record.
Phoebe McClure on behalf of the people, filling in for prosecutor of record David McCready.
Stan Sal on behalf of the defendant Matthew Highland.
Okay, and Mr. Sala, where are we with Mr. Highland's case?
I did submit a thumb drive to Mr. McCready's office. I believe they're still working on downloading Facebook messages, from what I understand, is what he told me when we submitted the thumb drive. So at this point, I think we just need an adjournment.
Ms. McClure, do you know if there's anything we need to address from the people's standpoint today?
I don't. I see there was a note to do that, to take care of those Facebook records, I guess, but I don't see that anything's happened since then. So I guess I have nothing to add.
All right, and I'm sorry, Mr. Sala, how far out were you looking?
Probably 60 days. Hopefully we'll get it and have an opportunity to look at them.
Go then with May 15th at 8:15, if that works for everybody.
Can we do it a week later than that?
That would be May 22nd.
Yes.
All right, so May 22nd at 8:15. Mr. Sala, can your office prepare that stip and order?
Yes, Your Honor. May I sign Ms. McClure's name on that stip and order?
Yes, you may.
Thank you. I'll get that done. May 22nd at 8:15.
Correct.
All right, thank you, Your Honor. Thank you, Ms. McClure.
Right, thank you then. Mr. Highland, you're all set. You can go ahead and log out.
Yes, sir. Thank you, Your Honor.
All right, Mr. Malero, Mr. Madrid has apparently left his Zoom pod. Can you call the jail and tell them Mr. Madrid?
Judge, that Zoom pod was, couldn't really
Oh, are
hear.
they they're trying to find a different one for him?
I hope so.
Okay. Yeah. I can call them and see what they are.
We're prepared to go forward, but I couldn't hear a thing he said.
Okay, we're calling the jail right now to try to get back. Mr. Murphy, are you ready to proceed with Mr. Stewart?
Yes, Your Honor.
Oh, this is Kelly. Change your statement.
Okay, this is file 23-21657-FH, People versus Zachary Allen Stewart. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record.
Phoebe McClure on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Stewart.
All right, and Mr. Stewart is here by Zoom. Mr. Stewart, can you just state your name, please?
Zachary Allen Stewart.
All right, and Mr. Murphy, where do we stand with Mr. Stewart's case today?
Your Honor, at this time, I was going to ask if we could, well, I thought maybe we should set trial on this date just to have a final end date for the case. I believe it'll ultimately be resolved short of the trial, though. I need to speak with Ms. McClure further and then speak to Mr. Stewart about her answer on some things. So I guess if the court would be okay, maybe another pretrial. But if the court is concerned with the length of time this case is taking, then we'll be fine with setting a one-day trial date.
Okay, Ms. McClure, anything we need to address from people's side?
I guess I would ask for one more for Mr. Murphy and I to chat. I am getting kind of a backlog of trials and trial setting being set back to back. So I'd rather not take up another trial date if it's one that might resolve.
Yes, Your Honor, with that, we'd be fine with setting another pretrial. Again, I believe it'll be resolved short of trial, and I would agree with Ms. McClure. There's no need to clog up her already clogged docket then of trials.
Well, I appreciate people's difficult dockets. The courts is busy as well. And the case is at 90 days. And, 90 days is, in my opinion, sufficient for negotiations to happen and offers to be made and decisions to be made. And so, that's where I need to start setting trials in order to try to stay consistent with what the court's guidelines are in terms of how cases should be processed. So I'll give you one more on this, but at the next one, we're going to set this for a trial. Let's go with April 17th at 8:15 a.m. if that date's all right with everyone.
Yes, Your Honor. Thank you.
That works, thank you.
All right, so Mr. Stewart, your next date is April 15th at 8:15 a.m. You'll log back in with all the same Zoom information that you used today.
Okay.
And Mr. Murphy, would you prepare a stipulation in order for that adjournment, please?
Yes, Your Honor. I'm sorry. Could you just clarify the date? I wasn't sure if that was the 17th or the 15th.
I apologize. I just misspoke. It's April 17th at 8:15 a.m.
Yes, Your Honor. Thank you.
Okay.
All right, Mr. Malero, while we're waiting for Mr. Madrid, I do have Mr. Paulding here. If you need a breakout session with him, we can set him up in the hallway. He's here in person.
Don't think I do, Judge, unless he wants one.
Mr. Paulding, do you need to speak with Mr. Malero before we have your hearing?
No, Your Honor.
Okay, you can come forward and sit at the table here closest to the television screen.
Judge?
Yeah.
Yeah, the jail just called and said Mr. Madrid is refusing to come back out.
Okay, thank you for that update. Okay, we are on the record now in file 23-21326-FH and 23-21449-FH. People versus Bush Lee Paulding. We are here today for pretrial conferences in both of those cases. We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record.
Allison Arnold for the people.
Salvatore Malero on behalf of Bush Paulding.
All right, and Mr. Malero, where do we stand with Mr. Paulding's case today?
Your Honor, where we stand is I'm asking the court to adjourn this out perhaps 4 weeks. I am making some progress in my negotiations with Ms. Arnold on some resolutions in these matters. So that would be the basis for my request for an adjournment.
All right, Ms. Arnold, anything we need to address from the people's side?
No, Your Honor, we concur with that request.
All right, so 4 weeks would be April 10th. How about April 10th at 8:15 a.m.?
That's fine, Judge.
That's fine.
Okay, and Mr. Malero, can you prepare that stipulation in order, please?
Yes, I will do so, Judge.
Okay, so Mr. Paulding, your next date is April 10th at 8:15. You can come back in person if you like, or you could also attend by video conference if you want. The bailiff will give you the Zoom information.
Okay, thank you. April 10th, right? 8:15.
Correct.
Hey, Mr. Paulding, come see me probably in a week or so, okay?
Okay.
Mr. Murphy, I do have Ms. Williams here. Are you going to need a breakout session with her?
If I could, please, Your Honor.
And Mr. Malero, I do have Mr. Lindsay here in person, I believe. Are you going to need to speak with him?
Yeah, I'll probably need to speak to him, Judge.
Okay, Mr. Lindsay, there's an iPad right outside the door in the hallway. If you go out there, I will bring that into the meeting and then put you in a breakout session with Mr. Malera. Sergio, that the camera on that is off and the microphone is muted. Can you go see if you can fix that? All right, Ms. Williams, I'm going to place you in a breakout session with Mr. Murphy, if you give me just a moment.
Okay.
No, I don't want to. Let's see if it works.
Okay, I think we're all set now. Thank you.
Judge, do you have somebody in the waiting room with a 419?
Give me just a second. Give me a moment.
I'm sorry.
There we go. It should work.
Okay. All right, so no, Ms. Walsh, I don't have anyone in the waiting room that is just here under a telephone number.
I don't know what they're logged in as. They're calling from a correctional facility in Ohio regarding Kayla Price. I just wanted to let you know that.
Okay, so I have Kayla Price is in the waiting room.
Oh, perfect. Okay. So they're calling from a correctional facility in from Ohio.
Excuse me.
Your attorney is across the hall with Judge Anselm. As soon as she's
I
back
just got
on.
off work at 6 o'clock this morning though.
I appreciate that.
I've been here since 8.
I appreciate that. I can't do anything without your attorney. As soon as she's here, I'll get to your case.
And would it all
Sir, all right, sir, stop. If you're going to be disruptive in court, you're going to find yourself in even more trouble than you are right now. All right, good morning, Miss. You are Kayla Ann Price. Ms. Price, your device is muted. I'm going to send you a request to unmute.
Thank you.
No, it's not.
All right, so we are.
Wait, whoa, nobody brought you here.
We are on the record in file 22-21109-FH and 21-20621-FH, People versus Kayla Ann Price. We are here today for arraignment on a request and summons for probation violation in both cases. We are proceeding today by video conference. Miss, you are Kayla Ann Price?
Yes, Your Honor.
All right, Ms. Price, you're before the court today on a request and summons for probation violation in both files. Have you received copies of those?
I have not, but I'm aware of the violation.
All right, so we'll make sure that we get you copies of those documents. They do, there's two, but they both allege the same thing. They allege that you violated the terms of your probation by pleading guilty to identity fraud, attempted possession of cocaine, and failure to appear in Putnam County, Ohio, and also by being positive for methamphetamine. Do you understand that those are the allegations against you?
Yes, Your Honor.
In file 21-20621-FH, you had pled guilty to possession of methamphetamine. The maximum possible penalty for that offense is up to 10 years in prison. Do you understand that?
Yes, Your Honor.
In file 22-21109-FH, you had pled guilty to possession of analogs, and maximum possible penalty for that offense is up to 2 years in prison. Do you understand that?
Yes, Your Honor.
You are entitled to have an attorney to represent you here today and at any other proceedings we have in this matter. If you can't afford an attorney, you can tell me that, and I will appoint one at no expense to you. Do you understand that?
Yes, Your Honor.
Would you like to be represented by an attorney?
Yes, please.
Do you have the ability to pay for your own?
No, Your Honor.
All right, I will have you. All right, Ms. Oh, there's Ms. Underwood. So I will have you speak with Ms. Underwood. I'm going to place you in a breakout session right now.
Thank you, Your Honor.
Sergio, is Mr. Kennedy still here? We have Ms. Hinton now.
Yes. You want him to come in here?
Yeah. Ms. Hennigan, are you ready to proceed with Mr. Kennedy? Ms. Hennigan, are you there? Ms. Hennigan, are you there? All right, her device is logged in. She's apparently not in front of it right now. Get to your case, sir, as soon as she back in front of her device. We have Ms. Underwood and Ms. Price back from the breakout session. Ms. Underwood, you know how Ms. Price wants to proceed today.
Thank you, Your Honor. Your Honor, I've discussed this matter with Ms. Price and also had communication with Ms. Walsh in this matter. And at this time, Ms. Price wishes to enter a plea in this matter. And I believe Ms. Walsh is going to be recommending that Ms. Price continue her program that she's doing in Ohio, Your Honor, and then continue on probation.
All right, Ms. Price, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Kayla Ann Price, correct?
Yes, Your Honor.
Do you understand that you have a right to contest the violation of probation charges and to have a trial on them?
Yes, Your Honor.
You can put your hand down if you like.
Okay.
You understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence.
Yes, sir.
Do you understand that you'd have the right to have all the witnesses against you appear at your trial? You or your lawyer could ask those witnesses questions, and you also have the right to have any witnesses you have for your defense to appear at your trial.
Yes, Your Honor.
Do you understand that you're not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way?
Yes, Your Honor.
On the other hand, you also understand that you have the right to testify at your trial if you wanted to testify.
Yes, Your Honor.
How do you plead to the charges that you violated the terms of your probation?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Have you been threatened in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I do, Your Honor.
Is it your own choice to plead guilty today?
Yes, it is, Your Honor.
You were placed on probation in the 22 file back in February of 2023 and in the 21 file back in March of 2022. Is that correct?
Correct, yes.
And each file has an order of probation in it. Both of those orders of probation have a signature on the defendant's signature line. Did you receive and sign those documents?
Yes, I did, Your Honor.
The terms of your probation require that you not break any laws. Is that right?
Yes, it is, Your Honor.
And did you plead guilty on December 21st, 2023 to identity fraud, attempted possession of cocaine, and failure to appear?
Yes, Your Honor.
The terms of your probation also require that you not use any controlled substances. Is that right?
Yes, Your Honor.
Did you use some methamphetamine on or around November 5, 2023?
Yes, I did, Your Honor.
All right. I will accept your pleas then. They've been given understandably, voluntarily, and accurately. Ms. Price has had full knowledge of her rights and she's had competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation and set sentencing for April 18th at 8:15 a.m. All right, so you are all set for today then, Ms. Price.
Thank you.
What is that date for sentencing, Your Honor?
That was April 18th.
April 8th?
18th.
18th.
1-8.
Thank you.
Okay, thank you.
Bye, Miss Price.
Bye, Ms. Walsh. Thank you.
Yeah.
Ms. Hennigan, are you ready to proceed with Mr. Kennedy?
Yes, I am, Your Honor.
All right, we are on the record in file 23-21426-FH20 and 23-21427-FH. Also 23-21578-FH. People versus Daniel Martez Kennedy. We are here today for a final pretrial conference in the 23-21426-FH file and pretrial conferences in the other two files. So first, let me ask the attorneys to place their appearances on the record, beginning with Mr. Fleming. Mr. Fleming, are you there? All right.
Appeared on behalf of people.
Okay. Sorry, you froze up for a minute there. Can you try that once more?
Absolutely. Chris Fleming appeared on behalf of the people.
Mayor
There we go.
Sonigan on behalf of Mr. Kennedy and my clients appearing in person in the courtroom.
All right. Ms. Hennigan, where do we stand with Mr. Kennedy's case today?
Thank you, Your Honor. I would ask that the prosecutor place their offer on the record for the court's benefit and for the purpose of future transcripts. Also, I would indicate to the court that my client still intends to go forward with trial on the 426 case. And also, we have pretrial on the other cases, as you've indicated, and he still intends to go forward with trial on those cases as well.
All right, Mr. Fleming, is there a current offer from the people?
There is. What I show Judge is if he pled it to count 1 in 2321427, which is possession of methamphetamine, and count 4, police resisting obstruction as a habitual third, and in case 2321578FH, count 1, firearm possession by felon, and count 4, police resisted obstruction, and count 6, malicious destruction of police property as a third habitual offender. The people would dismiss counts 2 and 3 in file 2321427. Dismiss file 2321426FH in its entirety, and dismiss counts 2, 3, and 5 in 23-21578FH.
Mr. Fleming, is that one dated November 28th of 23?
I see that as of November 9th of 23. Did that change?
I believe it did. Mr. Sneed sent out an updated one after that. I do have that one here though, but I wanted to make sure that you have it. I can place it on the record, but I want to make sure that you have the same one.
Go ahead and place it on the record. That way I can probably double check.
Okay. I'm sorry, Your Honor. I thought that we both had the same one. The plea agreement that I have, as I stated, is dated November 28th, 2023, sent by prosecuting attorney Isaac Sneed. And it states that if the defendant agrees to plead no contest to the following crimes, in file number 23-21578-FH, to count 1, firearm possession by felon, count 3, police officer resisting and obstructing, count 4, police officer resisting and obstructing, count 6, malicious destruction of property with the habitual third offender supplement, in file 222163 OM, to count 1, municipal paraphernalia possession. Then the prosecuting attorney's office will, in file 23-21427FH, dismiss all charges. And in file 23-21426FH, dismiss all charges. In file number 23-21578FH, dismiss counts 2 and 5. I just wanted to be clear that that was on the court's record, Your Honor, as I indicated, my client chooses to move forward with trial. We're set for trial on the 426 case next week. So I just wanted to be clear that the plea offer has been made to him, and he would like to move forward with trial.
All right, so we're set for trial on Tuesday of next week. Have you all provided jury instructions and proposed voir dire?
The people have provided that to the court, as well as Ms. Hennigan. I as well submitted a amended witness list back in February there with just Officer Robinson as the people intend to call.
Yes, and I believe that we provide our response to them as well for that, Your Honor. I will double check that today, but I'm pretty sure it's gone over too.
Okay. Are there any other evidentiary issues or anything that we need to address before we have a jury ready to go?
Not for this particular file, Your Honor.
I do not believe so, Judge. I think the people are ready to proceed.
All right, so we will see everyone back for trial then on March 19th at 9 a.m. So, Mr. Candy, you're all set. You are free to leave.
And Judge, I would leave that offer open until Friday, but after that, it's going to be revoked.
Okay. So we'll set pre-trials in the other two cases for the trial date.
Perfect. Thank you, Judge.
Thank you, Your Honor.
All right, Mr. Malera, are you ready to proceed with Mr. Madrid?
I think so.
Okay, we are on the record in files 22-20968-FH, 22-20969-FH, 22-20972-FH, and 24-21750-FH, People versus Michael Anthony Madrid. We are here today for pretrial conferences in all but the 2024 case. The 24 case is set for arraignment. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Salvatore Malero on behalf of Michael Madrid.
All right, and sir, you are Michael Anthony Madrid?
Yes, sir.
Mr. Malero, have you, does Mr. Madrid wish to have the information read in the 24 case?
Your Honor, at this time, we do acknowledge receipt of the information, waive its reading in open court. Mr. Madrid would stand mute as to all counts, including the habitual offender notice. We would also acknowledge receipt of the witness list. Ask the matter be set with pretrial for a pretrial, as well as in connection with his other matters, so that we could see if a resolution can be reached.
Okay, so we'll enter a not guilty plea for Mr. Madrid in the 24 case. Mr. Malero, how far out did you want to look for a pretrial?
Maybe 3-4 weeks, Judge. Maybe not longer than that.
We can do April 3rd at 8:15.
That'd be fine.
And I apologize, Ms. McClure, anything we need to address from the people's side?
Nothing to add, Judge.
Okay. So we'll set it for pretrial on April 3rd at 8:15. Mr. Malero, can you do stip and orders for the 2022 files?
Sure, Judge, I'll do that.
Are we
All
going
right,
to do the violation sentencing?
Well, that's what I'm asking to be rescheduled.
I think he wants to try to resolve this and sentence all at the same time. So I'm going to give him a couple weeks to try to do that.
Okay, because that'd be a new violation if anything comes out of that new file, just so you know. So this one can go if be great.
The moment we're going to hold off until April 3rd. So Mr. Madrid, you can let the officer that's with you know that you are done with court for today.
Thank you, Judge.
Call for Harley Bussing, please. Mr. Malero, are you ready to proceed with Mr. Lindsay?
I am, Your Honor.
Mr. Daly, we're just calling for Mr. Bussing now. Okay, we are on the record in file 24-21749-FH, People versus Jason Floyd Lindsay. We are here today for an arraignment in this case, and we are proceeding today partially by Zoom and partially in person. First, let me have the attorneys place their appearances on the record.
Thank you.
B.B. McClure on behalf of the people.
Salvatore Malero on behalf of Jason Lindsay.
All right, and sir, you are Jason Floyd Lindsay?
Yes.
Mr. Lindsay is here in the courtroom in person. Mr. Malero, does Mr. Lindsay wish to have the information read?
Your Honor, at this time, we would waive the reading of the information in open court, waive any defects of time and place of service. Mr. Lindsay would enter a plea of not guilty and ask the matter be set for pretrial. There is a possible resolution that I need to review with Mr. Lindsay, so I'd say probably 3 to 4 weeks should be enough time.
I'll enter a not guilty plea for Mr. Lindsay. Ms. McClure, is there anything we need to address from the people's side today?
Nothing, thank you.
All right, let's set it for a pretrial on April 10th at 8:15 a.m.
Thank you, Judge.
So Mr. Lindsay, your next date is April 10th at 8:15. You can come in person if you want, or if you prefer to attend by Zoom, bailiff can give you our Zoom information. You can do it that way.
Okay, may I ask something? I did,
So, Mr. Valero, Mr. Lindsay wants to ask something directly to the court. Are you okay with that, or do you want to just speak to him later?
Well, Judge, I always get nervous when clients want to talk to the court without running it by me first, so. I have no idea what he's gonna ask you.
If you want to step outside to the iPad, I can put you in a breakout session.
okay, thank you, I appreciate that.
Okay. Okay, Mr. Murphy, are you ready to proceed with Ms. Williams?
Yes, Your Honor.
We are on the record in files 23-21660-FH and 23-21661-FH, People versus Lori Ray Williams. We are here today for pretrial conferences in both of those cases. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Matt Murphy appearing back from Ms. Williams.
All right, and Mr. Murphy, where do we stand with Ms. Williams' case today?
Your Honor, at this time, Ms. Williams is asking for the court to set jury trial on these matters. Well, I think we'd obviously need two separate trials for the two separate cases because they're two separate instances. But would ask the court to set trial. We believe that to start out with, it would probably be a one-day jury trial, unless Ms. McClure had a different opinion on that.
Ms. McClure, any thoughts on length of trial?
Well, I would, I guess if Mr. Murphy won't stipulate to it, I would file a motion to consolidate these cases if they're domestic violences and they're the same victim. So obviously we would, as other acts, I'll file whatever notices I need to file, but they would be admissible in both cases per the statutes. So I do think we could just get one trial day and they could be consolidated for now. And then if the court rules otherwise, we can get a second trial date. But otherwise, nothing to add. I think maybe 2 days, but maybe a day would be fine.
I think even if the court ruled that it was appropriate to try on both, that one day would be sufficient. Or maybe I'm wrong about that, but I think even given both, one day would be sufficient.
And for the record, my offer right now is to plead to one case and dismiss the other case.
All right, so Ms. Clark, can you find us a one-day jury trial date, please?
Would you like that backed up to anything, Judge?
That's fine with me if it's a backup.
Friday, June 21st at 9 a.m. a backup to Donald Lester.
I'm sorry, I missed that date. I didn't hear.
June 21st.
That'll be fine for myself.
1 second. That works for the people.
21st. Let's do a final pretrial on June 12th. All right, so I would like to hopefully resolve the consolidation issue as quickly as we can, so everybody knows what is going to happen going into that. So if we need to file a motion and need to make a ruling, please get that in front of me as quickly as possible.
Sounds good.
Phoebe, I'll talk with you. I'll give you a call later today or tomorrow about that.
Okay.
All right, so Ms. Williams, you can go ahead and log out then. Court will issue a scheduling order with all our relevant dates in it.
Thank you, Your Honor.
Thank you. Mr. Daly, do you need a breakout session with Mr. Bussing? Sorry, Mr. Daly, if you respond, you're muted.
No, Your Honor, I don't need a breakout date, and I would advise the court that last week we were here and he had an appointment. We were trying to get an appointment scheduled for him to be screened. And that appointment, we just found out today or yesterday, is being scheduled for tomorrow, Miss Teskey. So I would rather set this over for until we can know what the results of the screening are, or we can set it for trial. I don't care. I just wanted to make the judge, I just wanted to make you aware of what's going on. There's going to be a plea if he's qualified.
All right, so let me just call the case real quick. It's file 24-21728-FH People versus Harley Victor Bussing Jr. Today's set for a pretrial conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, on behalf of the people.
James Daly on behalf of the defendant, Your Honor.
Okay, and so Ms. McClure, I presume you heard Mr. Daly's statements about having a screen set up for drug court. Do you have any objection to adjourning this until we know that the results of that screening?
No, no issue with that.
Okay. Let's set it then for March 27th at 8:15. Anything else I need to address with Mr. Bussing's case today?
No, Your Honor.
All right, thank you, Mr. Bussing. You can let the officer with you know that you are done with court for today.
All right. Thank you, Judge.
Okay, Mr. Malero, I see that Mr. Lindsay is back in the courtroom. Is there something further we need to address with his case today?
There is, Your Honor.
Okay. Mr. Lindsay, if you want to come back forward, please. Back on the record in People versus Jason Floyd Lindsay, 24-21749-FH. Mr. Malero, you indicated there was something further that you wanted to address with the court today.
Yes, Judge. We are asking the court to consider modifying Mr. Lindsay's bond conditions to remove the no contact order. The basis for that request is that alcohol seems to have been a factor in this matter, number one. One of his bond conditions is that he takes PBTs twice a day so that alcohol does not continue to be a factor in this matter. My understanding that Mr. Lindsay is compliant with that. Second, Judge, I was contacted by his wife, who is the subject of this case, and her indication to me was that in addition to other things, she wanted him to get help, which is happening, but it was my understanding she also wanted the no contact order lifted. So I'd ask the court to consider modifying that bond condition to perhaps to allow contact, but that there be no assaultive or obstreperous behavior on the part of Mr. Lindsay. That would be our request, Judge.
Ms. McClure, any response from the people?
So I haven't had to deal with this for a while, but isn't there counseling that has to be done on both parties before we can lift a no contact?
Well, it's not a requirement.
Okay, well, I don't believe that that's happened yet, so I guess I would ask that that happen first. And then what was the first part of your request?
Just that he, just the no contact be lifted.
Oh, okay, nothing with the alcohol then.
Well, he's doing PBTs twice a day. We are not asking that to be changed.
Okay, yeah, I was gonna say, as if the no contact's lifting, we obviously want that to stay in place. But I think typically there's I can't remember the name of it, but there's a counseling group. Our victims' rights have the contact info for it that both parties would undergo. Unless Mr. Coast knows.
Yeah, typically to get that modified or lifted, the victim would have to actually reach out to the Catherine Cobb shelter. And typically the defendant would have to reach out to John Bailey. And then once the magistrate receives both of those, that the parties reached out to them, then it could be lifted.
The other thing that kind of concerns me, Judge, is that him and his wife had a domestic incident in Florida in October of last year, so October 2023, and that was actually pending when this offense took place. So I guess maybe what I'm saying is if the court agrees that it's okay, that we lift the no contact, but he not be allowed to go back in the home or live back in the home at this time until we have a resolution to the case.
Yeah, we're not asking he goes back in the home, just that the no contact be resolved.
Okay, I do have in the court's file, filed on March 12th, communication from John Bailey that indicates that both Mr. Lindsay and Miss Lindsay had met with him to discuss their counseling options and better understand domestic violence, and also that each of them, or that Mr. Bailey believes that each of them understood the information that was presented to them. And it also indicates that Ms. Lindsay is requesting that the bond condition be lifted. So on the basis of that, I will remove the no contact provision, but as discussed and agreed to by Mr. Malero, that does not mean he can live in the same household with Ms. Lindsay. There will still be a restriction that he not live at the same residence. But in terms of removing the no contact, I will remove the no contact at this time.
Thank you, Judge.
Are we all set on that case then?
Yes, we are, Judge. Thank you very much.
Okay, thank you. Okay, Mr. Malero, I believe that's everything that I had for you today.
You do not have Michael Chittenden on your docket, Judge?
I do not.
All right. Thank you then, Judge. Appreciate it.
Okay, thank you. Mr. Murphy, I do not believe we have Mr. Perez here today. Do you know anything about his whereabouts?
Your Honor, I called Ms. Perez and left a message a little bit ago. Yeah, we received no answer yet. I don't have any message from my office that she's called or anything, so I apologize, Your Honor. I don't know where she is.
All right, this is file 23-21664-FH People versus Teresa Renee Perez. We're here today for a pretrial conference. First, let me ask the attorneys to place their appearance on the record.
BB McClure on behalf of the people.
Matthew Murphy, appearing on behalf of Teresa Perez.
All right, and I did have a brief discussion with Mr. Murphy off the record. Ms. Perez is not present by Zoom today. She is also not here in the courtroom. Mr. Murphy, is there anything you'd like to state on the record with respect to that issue?
Your Honor, I had called Ms. Perez earlier this morning in hopes to talk with her before we went into the court or on Zoom. I left a message. There's a number that we have on file. It is a number that I've used previously, but of course, I don't know if she received the message. I guess, I do apologize for her absence, Your Honor. I'd ask the courts maybe to adjourn, to refrain from doing a bench warrant, perhaps. I understand that she isn't here, but I do believe that if she makes contact, she will reappear maybe later today or tomorrow. So I would ask the court perhaps to refrain from doing a bench warrant, but obviously I don't have any explanation or excuse for her absence.
Ms. McClure, anything you want to address from the people's side today?
Judge, my review of Ms. Perez's criminal history, she does have a history of failure to appear, particularly in district court. And I believe last time we were in court, she did have active district court warrants for failure to appear. I think they were all minor. It might have been a probation violation, but she also had an attorney general warrant for failure to pay child support. And she has an absconding from back in 2022 as well, and circuit court, in this circuit court. In addition, I think the last time we were in on Ms. Perez's case, her phone was dying. So I would ask the court, and we couldn't hold a full pretrial, maybe it was 2 pretrials ago, but I would ask the court to issue a bench warrant with a 48-hour hold, and then on a subsequent pretrial, if she is located and appears, that she be ordered to appear in person so that we could actually pretrial this case.
Okay, so what I'm going to do is give her the 48-hour grace period. If we haven't heard from Ms. Perez within 48 hours, I will at that time revoke and forfeit bond and issue a bench warrant for her arrest. I would set bond on that bench warrant in the amount of $10,000 cash or surety.
Yes, Your Honor. Thank you.
Okay.
And that's all that I believe I had in your court, Your Honor, this morning. If I'm wrong,
yeah,
please contact. But
that is all I had for you. Thank you, Mr. Murphy.
Thank you, everybody. Have a good day.
Okay, Ms. Underwood, we still do not have Mr. Moreno. Do you know anything about him?
Your Honor, Mr. Moreno bonded out, and I'm not sure where he is at the moment. I've talked to Ms. Brunner, Your Honor, and I don't believe she would have any objection to putting this out 2 weeks and seeing if we can locate Mr. Moreno and see what the misunderstanding was, Your Honor.
Oh, yeah.
That's correct, Your Honor. I don't have an objection. Hopefully council can get in touch with them and we can get them to appear next time.
Okay. All right, so this is file 24-21, I'm sorry. 24-21714-FH People versus Jesus Joseph Moreno. We're here today for a pretrial conference in this case. First, let me have the attorneys place their appearances on the record.
Sarah Brenner, Assistant Attorney General for the People, Your Honor. Good morning.
Rhonda Underwood for Mr. Moreno, Your Honor.
Excuse me. So we just had a conversation regarding Mr. Moreno's presence. I don't know how much, if any, of that was on the record. So just to summarize, Mr. Moreno is not present here today, either by Zoom or in person. I did discuss that issue with Ms. Underwood and Ms. Brenner. It's my understanding that both Ms. Underwood and Ms. Brenner, you're in agreement with setting this out a couple of weeks to see if Mr. Moreno can be reached and appear at the next pretrial. Is that right?
That's
correct, Your Honor.
Okay. Let's set it then for April 3rd at 8:15.
Thank you, Your Honor, and I will be happy to do the stip to adjourn with Ms. Brenner's permission.
Yes, thank you, Rhonda. Thank you, Judge.
Okay, thank you very much. Then I think that's it for this case. All right, Ms. Underwood, do you need a breakout session with Mr. King?
Yes, Your Honor.
Okay, Mr. King, if you give me just a moment here, I'm going to place you in a breakout session with Ms. Underwood so you can speak to her privately. Okay, we are on the record in file 23-21419-FH, People versus Derek Eugene King. We're here today for arraignment on a request and summons for probation violation. We are proceeding today by video conference. Sir, you are Derek Eugene King?
Yes.
Mr. King, have you received a copy of the request and summons for probation violation?
No.
Give me a moment and I will put it up on the screen for you. We'll also fax it over to the jail.
Yeah.
Okay, Mr. King, I'm placing that up on the screen now, or did they get? Send it. Take whatever time you need to look that over and just let me know when you're finished.
Yeah, I see it. Dang ready.
All right. Okay, so Mr. King, the summons for probation violation alleges that you violated the terms of your probation by failing to report. To your probation officer. You had previously in this case pled guilty to 2 counts of assaulting, resisting, obstructing a police officer with a third habitual offender notice or third offense. That would make the maximum possible penalty in your case up to 15 years in prison. Do you understand that? You're entitled to have an attorney represent you with respect to this probation violation. And if you can't afford an attorney, you can tell me that I'll appoint one for you at public expense. Would you like to be represented by an attorney?
Yes.
Do you have the ability to pay for your own? Do you have the ability to pay for your own attorney?
No.
All right, so I'll appoint the public defender's office to represent you. You've already spoken to Ms. Underwood. Ms. Underwood, you need to speak with Mr. King any further.
Yes, Your Honor. I believe he is qualified for public defender. I've spoken with Mr. King. It's my understanding this is a technical violation, Your Honor, and Mr. King wishes to plead guilty to it.
All right, Mr. King, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
Do you understand, Mr. King, that you have a right to contest the violation of probation charge and have a trial?
So technical violation, what's the technical violation? I really don't understand. I mean, the technical.
Mr. King, a technical violation means the probation department is limited in the punishment.
Oh.
They can.
Okay. Okay. All right. Well, yes, I had COVID week 1 week.
Mr. King, I'm sorry, but I have to ask you questions to make sure you understand what your rights are before you talk further about the situation. Okay, so can we just get through that real quick?
Yes.
Okay, so do you understand you have a right to contest the violation and have a trial?
Yes.
Do you understand that throughout that trial, you'll be presumed innocent until your guilt is proven by a preponderance of evidence?
Mm-hmm.
Is that a yes?
Right. But I guess
Mr. King, I have to finish the questions that I have to ask before I can let you speak further, okay?
Yes.
I'll give you an opportunity when the time is right. I just have to get through what I have to get through first. You have a right to have all of the witnesses against you appear at your trial. You or your lawyer can ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes. Yes.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you'd also have the right to testify if you wanted to testify. Do you understand that as well?
Yeah.
Is that a yes?
Yes.
How do you want to plead to the charge that you violated your probation by failing to report?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Has anything been promised to you in order to get you to plead guilty?
Huh? Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Have you been threatened in any way to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. You understand that?
Right. Yes.
Is it your own choice to plead guilty?
Yes.
So you were sentenced and placed on probation back in this case back in the beginning of February. Is that correct?
Yes.
And at that time, one of your conditions of probations was that you report to your probation officer as instructed. Is that right?
Yes.
And the allegation is that you didn't report at any time after the sentencing. Is that what happened?
Yes.
Okay.
I contacted the probation department. I got sick, and then I kind of issues.
Okay, but did you ever go in and report?
No, I didn't get a chance to.
Okay, why didn't you get a chance to?
Well, I went to trying to get my. I got sick the 1 week. I had COVID. Then the next week, I was trying to get my finances straightened out for my family, and I don't know, my money was somehow my money had been locked in my and I couldn't use my card, get in my finances, and I was just trying to deal with a lot of issues that I had money saved. I could not get access to it, still can't get access to it. My ID, I lost the ID, so I have to send proof of that or birth certificate, things that I've been, a lot of my information and personal stuff is lost, so I can't. I've been going through a lot of trying to get a hold to a lot of my personal information so I can get access to my income. And I gotta prove that I'm me to even get to any of it.
All right. I am going to accept your plea. I understand what you've said. The instruction was that you report to your probation officer immediately upon release from jail. And I know you've outlined some difficulties in your life that you've had since you got released, but I don't think any of those rise to the level of excusing the not coming in and reporting.
Right.
You would have been able to do that despite the difficulties that you've talked about. So I am going to accept your plea. It's been given understandably, voluntarily, and accurately. You've had full knowledge of your rights and had competent counsel.
Right.
Your Honor, may I be heard as to the issue of bond?
Go ahead. What is it you'd like to say?
Your Honor, as you know, this is a technical violation. Mr. King is an older gentleman who was in jail for a long time. He got out of jail, and as he said, his financial situation is precarious at best due to the, I believe the prolonged period in jail has kind of exacerbated that. He's trying to get his ID so he can get his income restarted, Your Honor. I would ask that Mr. King be released from jail to make whatever strides on that he can, Your Honor. It's only going to benefit everyone in the long run to have that done. And I don't believe Mr. King meant any disrespect to the probation department. And I don't believe
so he's in jail now, not related to this. So if I issue a PR bond, is he going to be released?
He's on a parole violation as well.
Well, that's Dave face. Yeah, I'll be released from that too.
He also has no residence that I know of.
All right. So the practical reality of the situation is that
You have to have our rent. I have to have ID in order to get the income to get that residence.
The practical reality of the situation is that there's a limit of 15 days in jail for a first technical violation, and because I am out next week, I'm not able to conduct a sentencing hearing within that 15 days. And therefore, I believe I have to issue PR bond if we're going to go beyond the 15-day period. So I am going to do that. I'm going to order Mr. King that you, upon leaving the jail, you need to walk across the street and report to Ms. Holly or check in with probation, whoever is there at the time. I want you to understand that if you don't do that, and if you don't show up at probation and report at any other point, when you're directed to, it's going to be another violation.
Okay.
Okay, and then if there's a second violation, the limit isn't 15 days, it's 30 days. If there's a third violation, the limit's 45 days. And if there's a violation after that, the court can revoke probation and impose any sentence that I could have sentenced at the original sentencing.
Okay.
So if you keep not reporting when you're ordered to report, you know, if you do that enough times, ultimately,
yes,
your probation can get revoked, and your original guidelines in one of the cases was a prison sentence. So you need to understand all that as you are making decisions on what you're going to do. But for now, for the reasons stated, when you issue a PR bond.
Do you have residents?
Let's hold off on an address, Ms. Holly. I don't want that broadcast on YouTube. So I'm going to set sentencing for April 4th at 8:15 a.m. Again, as soon as you're released, you need to walk across the street and check in with probation. And I'm going to place you in a breakout session with Ms. Holly so that she can get any contact information that you have.
Okay. Okay.
Give me just a second to click the right buttons. Okay, so we can call people versus fair. Okay, we are on the record in file 22-21104-FH, People versus Bailey, Christopher James Barron. We're here today for a hearing on a summons for probation violation. We are proceeding today by video conference. Record should reflect that this matter was set for hearing on a probation violation summons this morning at 8:15 a.m. Mr. Barron was ordered to appear here in court at that time. He has not appeared either in person or by video conference. I am therefore going to issue a bench warrant for his arrest, and I will set bond on that bench warrant in the amount of $10,000 cash or sure. You Ashley Nicole Bean. All right, we are on the record now in file 23-21399-FH, People versus Ashley Nicole Bean. We are here today on a summons for probation violation. We are proceeding today by video conference. All right, so reviewing the request and summons for probation violation, there is no date set in that for a, oh, I'm sorry, there is. I missed that. So yes. The record should reflect that this matter was set for hearing on a summons for probation violation this morning at 8:15 a.m. Ms. Beam was ordered to appear. She has not appeared either by Zoom or by coming to the courthouse in person. I'm going to issue a bench warrant for her arrest for that failure to appear. And I'll set bond on the bench warrant in the amount of $10,000 cash assured. Ms. Underwood on People versus Jones. I don't have MDOC here today. And I do not see a writ in the file for his appearance. So we're going to need to adjourn that. Mr. King, you're all set. You can let the officer with you know that you're done with court.
Okay, thank you. All right, thank you.
Okay, so let's adjourn Mr. Jones. Let's go with April 17th, if that's all right.
4/17, Your Honor. And will the prosecutor be doing the writ on that, Your Honor?
Yeah, it looks like we missed it this time. I'm not exactly sure how, but I'll follow up with staff to make sure we get it for the next hearing.
I will do the stip and order with Ms. McClure's permission.
No objection. And what was that next date?
4/17.
All right, and so that leaves only Mason Lindeman, who was.
We needed I think a special PD appointed on that case, Judge.
Oh, we did?
That was the last time we were here. He was getting arraigned on his failure to appears, and we had set this underlying for a pretrial, and we needed, yeah, we used, it looked like you had signed an appointment for a special PD. Because Elias Mawad withdrew from the case, and he's already had the public defender's office, basically fired the public defender's office, and yeah.
So he was also in Jackson County Jail.
Yes.
Until at least April 5th.
Yeah.
According to the notes I have, they are not logged in with him today. And so why don't we?
Am I free to go to Judge Anzalone's, Your Honor?
Yeah, go ahead. So why don't we set it? Why don't we set it for April 3rd for a pretrial then?
And that order was signed, right? The one assigning a special PD.
The last thing I have is in the file is a February 29th order just appointing the public defender's office.
Okay.
I don't, when they move to a special public defender, I don't think I typically sign an order until it's been through Mr. Castleberry and he's appointed someone. That happens internally in the public defense office, I believe. I'll follow up and see if there's anything else that we need to do, but I don't think there is in terms of getting him a special public defender.
Okay. Yeah, I guess who can we talk to over there to make sure that happens? Because this is an older case. I'd like to get some
Yeah,
movement
I'll,
on it.
like I said, I'll follow up on it, and if there's any further order the court needs to sign right now, make sure that happens.
Okay. Yeah, and if there's anything I can do, let me know too.
So can you do a writ for him for the next hearing?
Yeah, it looks like we sent something to Jackson County for today. We never heard anything back, so I'll see if we can get something out.
Okay. All right, I think that covers everything that I had for today.
Okay.
Thank you very much. Have a nice day. Yeah. You guys want to get the stand? Sure. Because it's easy to hear. Actually, you have to do it. Yeah, right. Yeah. Good morning. We have more stuff. Great. Great. We have more stuff last night.
Yay.
So we're gonna run back out and get, we have some more stuff. Go ahead and have a seat. We'll be right back.
Did you empty that? Did you empty that? No. You had them in your pocket while you went through there.
The medicine?
Yes.
Yeah. You just empty out things that are.
I had cleaned it.
One here.
Oh. Oh, really?
1960 and 1929. Some picture frame to do that.
Yeah.
This is 36 to 43.
What was 36 to 40? She was bringing. Hi, how are you? Here, we're not fine for this pretrial release.
All the normal stuff are.
Yeah.
Whatever he had on his prior bond conditions all remain the same.
Sure.
Was this
Lindsay.
Starts with number
Oh,
five.
no, because I was like, I just wanted to remember.
Yeah. What you modified.
Right.
There, it's just important.
Jail.
Okay. Just start, Mr. Buster.
Oh, I already did. Oh, and it's fine. And I heard his notice that he didn't tell Daly to do it.
Or did we do?
Yeah. And he's still streaming live, by the way, so.
So we should do.
So they're offered.
The hair was really cute.
Or what? Last FHA, the rest is like 11,000 in closing costs.
I mean,
But
it's like a short track, so you can still.
Right now, it's just coming back here. Right up on here, 'cause
Yep.